I've been doing this for 20 years. I've been on NBAR Forms Committee over the years, been on the Attorney Roundtable to provide suggestions to that committee, been keynote at the NBAR convention and the breakout sessions 8 times over the last 2 decades. Most importantly, just having sat at the table and worked on somewhere conservatively between 15 and 20,000 closings, you just see things. And then you see things repeat and repeat and repeat, and you realize that they become discussion worthy, that they become worth mentioning. And regardless of the level of acumen of the agents, they're things that seem to replicate themselves, from the newest agents to the most experienced. Tuesday, we did a couple-hour class, and in 2 hours to get through 41 paragraphs, for those of you that were here, obviously we just touched upon issues here and there, nuances. We tried to find items that were problematic and potholes and pitfalls to agents, but big macro style items. And while we're by no means going to dumb it down here today, there will be some points that are more rudimentary than others. But I bring them up not to insult you in any way, but rather because they're things that happen over and over again. So just to kind of create that laundry list in your mind of things that you need to be clear of. This is the first of probably 40 discussions that we're going to have. And obviously we're not going to have it daily or weekly, but probably on a monthly basis where we'll just move chronologically through the contract. Today we're going to just discuss the preamble, which is the first 10 lines of the sales contract, and then the real property paragraph. There's plenty of substance here. Now this could be 20 minutes, this could be an hour, I don't know. I would encourage you to ask questions because this is the forum, certainly, to do it in. My colleague, Brendan, handles all of our Maryland transactions, and sidebar, we are in Maryland, DC, and Virginia, so happy to help you in all three. Said to me the other day, he was looking at the PowerPoint, which fortunately, he said, you got 30 slides on 15 lines of text. How is all that there? And again, some of these will buzz right through, very rudimentary. Others will take a little bit more time to digest. So bear with me on that. Hopefully this will be a discussion and we'll move forward. Again, as I said in the CE class on Tuesday, just make sure you're using the current forms. Everything we're going to work off of, at least until we move forward a number of months and they put out a 720 version of the sales contract, is going to be the 1219 version. So be sure when you're writing your contracts, when you're accepting your offers, that you're using, the 1219 version of the sales contract, 719 for all of the agencies. All right, let's go ahead and get into it. And, it's perhaps an unfortunate coincidence. I only discussed one point as it relates to the preamble and the first paragraph of the contract in the CE class. It's also the first point I'm going to discuss here today. So bear with me if you were at the CE class. I want to discuss it again, only because it's the first line of the contract. So it sort of unfortunately comes by coincidence the same first point that we touched upon in the CE class. If you totally got that point on Tuesday, enjoy your lunch, check your email, whatever. For some of you, there may have been some confusion, and for others of you, you weren't here at that class, so we'll talk about it. And what we talked about is that first line of the contract says this sales contract is offered on blank. That blank says date of offer after it. And what we pointed out were these quotation marks. And anytime we have quotation marks and parentheticals in the body of the sales contract, it's because we're defining a term. We see it with buyers, seller, listing brokerage, cooperating brokerage, default, contract, settlement date, settlement agent, contingencies, right? They're all defined terms. And the reason that the Forms Committee does that is because we're going to use them later in the body of the sales contract. And when we use them later, we're referring back to when we defined it to set up the rights and obligations. And so while this probably seems, up until this point, the very easiest blank to fill in the entire contract. It's today's date. Of course, the 15th covered. 23rd? 23rd. Right? Easiest blank in the whole contract to fill out. We do it without thinking. This contract is made on January 23rd because we're sitting with our clients this morning.
Well, what if they don't sign till the next day? I've always wondered that. Like, do I have to go back and change the date?
Well, what I want to be clear about is that doesn't matter.
Okay.
And it doesn't matter anymore that we're sitting with our clients here today on the 23rd. Because what we want to change is our perception of this contract. And we want to understand that when we are filling in blanks, we are setting up rights. We're setting up obligations. We're setting up repercussions. And when we're filling out date of offer, we have to know, why did we define it? Because if it wasn't meant to be used later in the contract, it would just say this contract is offered on today's date. But yet we've defined it, which means we're going to use it again later in the body of the sales contract. Ergo, when we're defining it, it's important to understand what rights and obligations we're setting up. And it's only used twice in the body of the sales contract. We may have to go off our
I think
Sorry,
you have
you
to
didn't catch
point
me.
it to the computer itself.
Oh.
Very good. It's used in paragraph 10.
Thank you.
Property maintenance and condition paragraph. Right? And in that paragraph, it sets up the property conditions the seller must deliver to the buyer on the settlement date.
This is my biggest question.
And it says that I gotta get a broom clean for your debris. We all know this. We'll talk about it in 10 weeks, 10 months, whatever, when we do our paragraph 10 discussion. Right? But in the condition to be determined as of, and we select our box here. Right? And most of you, when you got your license and you first went through the contract, there was a recommendation from your practitioner that you select date of home inspection. I don't want to dive too deep into this piece right now, but date of home inspection, we've got a nice barometer for what the property condition is going to be. The buyer goes in, here's the inspection. If it doesn't work, I can ask for it. Right? If it does work, I have the right to get it in that same condition on the settlement date. Right? We're setting up property conditions. So date of inspection is a good barometer for it. But yet we're in a competitive offer, escalation clause style market right now where buyers are waiving all sorts of things, chief among them home inspection. And if I'm waiving home inspection, the last thing I want to do is check that box. Because then what condition do I get? There's an ambiguity. Ambiguity is the enemy of all contracts. So if you're waiving home inspection, we would tell you, check date of offer. And that way what you see on the date of offer is what you get. Well, now let's go back to paragraph 1 of the sales contract. This contract is made on January 23rd. Did we just come from the house? Maybe. If we did, we're in real good shape, because we know what the condition is if we put January 23rd as our date of offer. But chances are we went around on Sunday and we saw 10 different properties, right? And maybe a day or two went by and now we're talking about it, we're writing our contract, whatever the case may be. Say we get around now to Thursday writing a contract on something that we saw on Sunday. If we're waiving home inspection and we're selecting date of offer, well, we better know what condition we're gonna get. Which means we're not putting today's date. We want the property in substantially the same condition as it was on Sunday, which is the 19th of January. So we're going to put this contract is made on January 19th. Because now we know what property we're going to get. Because my worst case scenario that I brought up to you in the CE class was what happens if a pipe bursts on Tuesday. And the sellers get all sorts of flood damage, right? And they clean it up, but then they call an attorney and they say, I'm selling the house, what should I do? Well, if they send the contract to me, I'm going to say, well, you're probably going to have a major problem no matter what. But you've agreed to sell the property in its condition as of, and this buyer put Thursday. It flooded on Tuesday, so you're providing the property in substantially the same condition as a flooded property. If you and your buyers put Sunday, when you knew it was in good shape at the open house, now you have a remedy because it's not substantially the same condition. Does that make sense? Right? And that's why these blanks, they have consequences. Understand what you are creating when you're putting that blank in. Yeah.
So, if you saw it in an open house on Sunday, you're gonna waive the home inspection, so the following Friday, you decide, you sit down with your client and you're saying, okay, putting down my date, and you backdate it to Sunday. I mean, I see what you're saying, like, it makes perfect sense, because that's, you know, the pipe broke and whatever, but do they look at that and go, wow, they've been sitting on this for a week, or it just doesn't matter?
I don't know what they would think, to be honest with you. I'm not a listing agent, and so I've never gotten a contract offer. If I, as an attorney, were to receive that, I would say, well, this makes perfect sense. They saw it on Sunday. See, notice when it defines date, it says this contract is offered on date of offer. It's not saying a subsequent parenthetical, the day you and your sellers are sitting, or your
down.
buyers are
Really,
sitting
that-
down to write it.
It doesn't matter.
It's
at that
saying the
point.
date of offer, and what's the date of offer? Barometer for
You
property
want-
condition and the
okay.
broker's fee. So
So you
we
would
have
wanna
to,
make it that
right,
way.
we have to change our mindset that date of offer isn't necessarily just when we're sitting
Sitting
down.
down,
And when we're
okay.
receiving an offer, date of offer isn't necessarily today, right? So it's setting up rights and obligations. And I
And
think
so-
that's an important consideration,
Right,
just to
and I
kind of
see
change
exactly
your
what you're saying.
framework.
Right, just change kind of your mindset on the whole thing, so, and then I guess then you'll address the broker's fee in a second, which
Mhm.
must also relate back to the date of offer or would be written up there.
Yeah.
So, I mean, that's not then a huge, it's not, it does not mean then when you sat down and wrote this.
Right,
Okay.
because it is a defined term that sets up rights and obligations used in the body.
Okay.
Right? And then again, paragraph 24, broker's fee. You're the buyer's agent. The amount of money you get paid is whatever is in writing as of the date of offer. And the flip side of that is the listing brokerage, they get what's left over. So it's an important consideration for both, particularly when we have adjusted the commission in recent days. Because if a week ago, I was offering $10,000 as a broker consideration, right? And then my seller got desperate, and my seller says, you know what, I'm gonna lower the price, I'm gonna up the buyer agency compensation to $15,000, right? Well, if you said, well, I was in Ryan's class, we saw it a week ago, we're gonna put a week ago. Well, guess what commission you get? You get 10,000, because that was what was in writing as of the date of offer. If I put today's date, I get 15,000, and vice versa. And of course, the listing agent gets whatever's left over, right? This is why you have so much difficulty with variable commissions in short sales, right? They say, oh, the commission will be reduced by, that's not what the buyer and seller agreed to. They agreed that what was in writing today was that I would get, let's just for argument's sake, say 2%, right? And now all of a sudden the short sale company, the bank comes back and says, we'll only allow an overall broker compensation of 2% total. You say, well, remember in the listing I put this language that we would lower it down, right? Number one, it wasn't reasonably ascertainable as of the date of the contract, but number two, the parties already agreed as to what I get. I get what was in writing on the contract date, not what the short sale bank comes back later. And you as the listing agent, you agreed to take what was left over, right? So just reconcile those two things, right? 9 times out of 10, if you're sitting there today and you saw it yesterday afternoon, nothing's changed. You're doing a home inspection anyway, so paragraph 10 is irrelevant, and the broker compensation hasn't changed. So none of this has any bearing or any importance, but it could. And that's just what I want you to recognize when you're writing that first date of the contract. Okay. All right. Accurately identifying the buyer, I will not speak down to you here, and I promise I'm not trying to be patronizing, but spelling, because I see it at least every other week, right? And of course, the way it comes through to us, I had one yesterday. My contract said Kristen, her name was Kirsten. She was paying cash, right? And even though we'd reached out to her a number of times via our system, somehow it just didn't get caught, but she came and sat down at the settlement table. Oh, my name's Kirsten. Please forgive me, right? I'm not gonna throw you under the table, but it makes us all look like bumbling idiots, of course. And I have no way of knowing, right? Not until we sit down and I'm looking at the ID and I'm like, ooh, this is great, like, right? Contract says Kristen, like, just try to make it accurate, right? We're searching them for judgments under their names and so forth. There's a trickle down that often happens that gets to the lender and so forth. And again, even though it doesn't directly make you look bad, we're not waving the contract in front of them to say, hey, look, this wasn't me, this was your, none, again, you've recommended us. Try to make sure we got it. Okay. Accurately identifying the buyer, the parties on the loan versus the parties on title, right? We just want to make sure that we kind of understand the framework here. The sales contract is a document conveying title in the property. So the parties on the sales contract, that's who you anticipate will be on the deed or the title to the property, right? Has nothing to do with the loan. So the example of mom and dad co-signing on a loan with the kids. No interest in being on title, we're just going to take ancillary responsibility as a co-signer on the debt. They don't go on the contract. They'll need to be at closing because they need to sign loan documents for the lender, but they're not acquiring legal title to the property. So it would just be the kids in that example. By contrast, go ahead.
So if something were to happen to the kids and the parents are legally responsible because they're on the loan,
Yeah.
then what happens to the title of the property?
Well, let's be clear, I would never recommend anybody co-signing on a debt to begin with. Secondarily, I wouldn't recommend anybody co-signing on a loan without having an ownership interest in the property. But nonetheless, I see it all the time.
Yeah, I was
Mom
gonna
and
say
dad,
that.
it's not our house, we're just helping you to qualify on the loan.
Right.
And if that were to happen, I had used kids as an example, so I'll assume, let's say daughter and her husband. Typically, there's a right of survivorship that exists there. So let's say daughter passes away, now mom and dad are responsible for paying a debt on behalf of their son-in-law, right?
Okay. But the title would, well, it'd still be in the
Right.
son-in-law's
Still
name.
go to the
okay.
son-in-law's name. Son-in-law dies, what's his will say, right? That debt is still gonna be binding. So, all these things are things that you wanna think about for estate planning if you were to co-sign on a loan, or for that matter, anytime you're acquiring a joint interest in real property. What do we want to happen if someone passes away? Because that's the only reason the tenancy is important, and then tracing that down the line. But again, for that matter, mom and dad might want to be on it with a right of survivorship, so that if son and daughter, pass away, they've got a responsibility to pay a debt, but at least they own a home, they can sell it.
Is that something that is state regulated, or is that federally regulated? As
Well,
far as
most of
way
the
that
laws are
tenancy works?
consistent state to state, but Virginia has its own estate laws. Like if I pass away without a will, every state has its own intestacy statute that defines where the property goes. Most of them are very similar. If I die without a will, generally it goes to my spouse, so long as I don't have children of another marriage. If I have children of a marriage, believe it or not, my spouse gets 1/3, my children of another marriage, regardless of how many, get 2/3. They split that. If I have no kids of another marriage and my spouse has passed away, then it goes down to my kids in equal shares, my kids up to mom and dad in equal shares, no mom and dad out to brothers and sisters, and then you just trace the family tree on out. But, have a will, you can give it to the church, right? Okay, so, like, whatever you wanna do,
Yeah.
right, you have that choice.
So if you have, Clark and Emily on the contract, and Clark is the only one applying for the loan,
Yes.
does the lender have an issue that Emily is on the contract but not a part of the loan?
It depends, and it depends on if Emily is also gonna be on title.
Yes.
If Emily's gonna be on title, right, and that's my other example, one
Okay.
spouse that potentially
Because
has
that's why she's on
bad
the
credit,
contract.
right? And so we don't want someone on the loan,
Mhm.
or in the alternative, we just wanna preserve that spouse's credit for another property or for something else, cause we don't need that spouse for qualifying purposes.
Right.
Right. Both individuals, husband and wife, are on the contract, cause they're acquiring the interest in the property.
Right.
Lender will have no problem with it, cause of course, that's what they want. These
Mhm.
two are on the deed, it's just one party is obligated to repay the debt. So when you're thinking about this sales contract, think who's gonna have title to the property, not who's going to be on the underlying. Okay? Again, if there are changes to this, let us know, right? We have to run every buyer for judgments, right? In order to provide our title insurance policy to the lender and to the owners. So while it's not prohibitive, if you get to the settlement, you say, who's this? This is Clark. Oh, well, we've never heard of Clark. We just have a contract for Emily. Tell me who Clark is, and then we can call the lender to see if he can be on there. We can run him for judgments. We can change all of our documents. But as you can see, that's a process. It's not just going to be instantaneous. So again, if you're privy to that information, even if your client's telling you, well, I'm the only one on the loan, but he's gonna take title with me, let the title company know, and then also anybody who's gonna be on title has to be at closing.
Right.
Sometimes there's that mental lapse that says, well, we've only got one party on the loan, right, we can add as many people as we want to the title. That's true, you can do that after the fact, but if you're doing it as part of closing, there are title documents that need to be signed. VA loan concerns, kind of flip that whole conversation on its head, because VA loans, while they are incredible loans for their borrowers, they have their own set of underwriting guidelines that don't parallel what we see in FHA and conventional. So you gotta understand how this one kind of augments a little bit differently. They require parallelism between who's on the loan and who's on the title. So you're not gonna have a cosigner on a VA loan. Further, in our example, if either Clark or Emily has bad credit and isn't going to be on the loan, VA is just gonna only allow that one spouse to be on the title. Now, if you have this scenario, they can certainly be added after the fact.
Yeah.
You can do a simple deed of gift, it's a couple $100, the turnaround time is a couple of days, where the spouse who was on the loan and on the title at closing signs a deed conveying the property over to them. You can do that after the closing.
What if they die?
If they die between settlements, and the change of that.
If they die and it's,
Jeez.
sorry.
Somebody's fascinated with that.
No, that's because I have a property that I'm working with right now, this is the issue.
Yeah.
So if it's a VA loan, and so only one, the person with the loan is the one on the title.
Yeah.
And then that person dies, then does it still go to their spouse?
Not automatically. You
But they're
go to
dead,
the-
so they can't sign
It would be,
paperwork.
it would be an estate. So hopefully that individual has a will. And hopefully that will says, when I die, everything I own goes to my wife. And if that individual doesn't have a will, then Virginia's intestacy statute's gonna get a hold of it. And like we talked about before, if there are no other kids, it's gonna go. But it's gonna go through an estate then. That estate's gonna need to be probated. It's gonna be subject to creditor claims, right? So if they're really in love, he would be well served to sign a deed conveying the property to both of them. Hopefully he's not watching, or hopefully she's not watching right now, right? If he thinks, well, Ginny doesn't recognize marital property, so if he thinks, well, I want to hang on to this interest because things have been rocky lately, well, that's a risk she would run if he were to pass away, that she would have to probate the estate. So she would be well served by saying, why don't we sign a deed, adding us both to the title? Then she has the exact same rights in their familial home as he does, whereas right now she doesn't have any ownership interest. But you need a deed to do that.
And Ryan can prepare that for you, for her.
Very good. I'm gonna say, yeah. Maybe the first time you've spoken up in a class.
I know.
Come on up. Like this thing. Indeed. So parallelism, yeah, between the loan and who is on title, right? So husband and wife, both on the loan, both on the title. Even though you're only using one certificate of eligibility, VA will allow husband and wife to both be on the loan. VA will not allow unmarried individuals to be on the same loan unless they both have a certificate of eligibility, which is generally not the case.
Is that the same for FHA? You can't be married.
FHA will allow an unmarried couple to both be on the loan,
Mhm.
or to allow one to be on the loan and both on title. It's VA that gets sideways on it.
Got it.
So boyfriend, girlfriend, fiancés, family members, right? If they're not on the loan, you're not gonna be on the title. Again, you can do it after the fact. But where this is important is when we're creating our contract. We wanna talk to the loan officer up front. Right, I'm working with an unmarried couple, right? Rather than you saying, well, sorry, only she's eligible, so, you know, you can't be on the title, right? I'm call the lender. We say, before we write this contract, I just wanna make sure, because I know VA has some pretty strict underwriting guidelines as to when we're using a certificate of eligibility, who can actually be on the loan. And then let's create the contract accordingly, because very often, I see these contracts prepared in the name of unmarried couples, and then the lender's coming back after the fact and saying, we need an addendum, and then there's ruffled feathers as to why can't I be on there, half of my money's being used, and so forth. Put this on the lender, deal with it up front so you don't have to deal with this issue then. Powers of attorney as well, as long as we're on it for VA. Make sure your clients are gonna be around or available at some point within the 24 hours around the settlement date that you're selecting, because VA will require an alive and well affidavit from them. And also powers of attorney for VA, many lenders, though not all, it's completely arbitrary enforcement, will require only a family member can sign as the attorney in fact for the missing VA borrower. Okay, so just something to think about there. Purchasing the property in the name of a revocable or family trust. Cash deals, certainly no problem. You put on there Ryan Stuart, trustee of the Stuart Family Trust, as your buyer, I can buy the property. Title underwriter's gonna need to see a copy of the trust agreement. So ask your buyer for it. That way we can properly prepare the deed, the title underwriter can properly provide the title insurance policy.
So if they want to buy it in the trust, it's not done yet, they have to buy the property first and then put it in the trust afterward? They can't do the paperwork as they go along purchasing the property?
I would not want to vest equitable title, which is what you're doing by ratifying a contract,
Mhm.
in an entity that didn't exist.
Okay.
So, it's not to say it couldn't be done, If we saw a contract dated today for a settlement that closes at the end of February, and then got a trust agreement that was created February 14th, we could still underwrite the loan, we could still, legal title could be vested in the trust as of the settlement date. Wouldn't be a problem for us, but my recommendation would certainly be to put the horse before the cart.
Okay.
More importantly, if they're not paying cash. 9 out of 10 lenders will not allow the borrower to take title in the name of their irrevocable or family trust. It adds an additional layer on the underwriting side. If I sign a note to say I'll pay you back and a deed of trust to say here's the property as collateral, if I do that individually, so long as I've got mental capacity, then it's valid, it's enforceable. But if I say, hey, I'm the trustee of the Ryan Stuart Trust, I'll sign it as that. Well, now we've got to make sure that I'm actually the trustee, that that trust was validly created, that I have the authority to pledge real property and to take on debt on behalf of the trust. That's a whole different layer of underwriting. And most lenders on institutional loans don't want to jump through that hoop. And so they will not allow your borrowers to take title in the name of the trust. When they do allow them, typically they'll require an attorney opinion letter. An attorney opinion letter is I'm saying, I know you're getting $1 million loan, I'm vouching for the enforceability of the trust. And if somehow it turns out to be not enforceable, I'm responsible for that $1 million. Attorneys will do that, but they charge you a lot of money for doing that. And the much cheaper recourse is just to take title individually, let the lender do their traditional job of underwriting the loan, and then a week after closing, convey it from yourself individually to your trust. Also, from an estate planning perspective, if you have a husband and wife who have a trust, Virginia's got a little quirk in the law that if they take title at the outset in the name of their trust, they don't have the creditor protection that a tenancy by the entirety would afford. Tenancy by the entirety only is for husband and wife, and it says if I die, you get it, if you die, I get it. But it also says if either of us are sued, that judgment doesn't attach to our home. And that's a big protection. If I run somebody over, if my business gets sued, and I've got personal liability, whatever it is, my home is not an individual asset. A couple who takes title in the name of their trust from a seller can't be tenants by the entirety. If they take title first as husband and wife as tenants by the entirety and then convey it to their trust, then they get the benefit of that creditor protection. It's a weird thing in Virginia law, but for that reason, if you have a husband and wife who want to put the property in trust, even if it's a cash deal, recommend that they go that next step of taking it individually and then going into the trust. All right? I get that's the next level stuff, but assignability. Paragraph 30. Again, it's relevant now because this is where it comes up. We want to identify up front who the buyer is, right? And we see contracts being assigned for any myriad of reasons. If I put it individually, and then I want to add my spouse to it, well, that's an assignment. I'm conveying, right? The equitable rights in the title are going from me to myself and my spouse. I'm assigning the rights, and I can't do that without the written consent of the buyer and the seller. So that's why we need an addendum when we make those changes. Lender always says, I need an addendum changing the contracts, because it can't be assigned. If it could be assigned, it would be a notice. I could say, hey, by the way, bring him or her along with me. No problem. You can't do anything back. That's not true. Buyer and seller have to consent. Right? Changing from an individual to a trust, or a trust to an individual. It's an assignment. And in theory, a seller could say, I'm not signing that. I don't want to do it. Right? Now, I don't know why they would. The goal is to get to the finish line. It's the pot of gold at the end of it. But we all know that the relationships between buyers and sellers sometimes get acrimonious. So people will do things for no other reason, just other than to spite the other party. They need to sign it. So all the more reason up front to understand who's my buyer going to be when I'm ratifying. Because I don't want to have to ask the seller for permission. And then our most traditional sense of assignments is when we have contract buyers. Right? I'm buying it for you for $500. And before I even close, I'm going and shopping it to somebody else. And I found somebody else that'll buy it for $525. And because I don't want to pay closing costs to buy it for $500 and closing costs to sell it for $525, what I've done is I've worked out an assignment of contract with my $525 buyer. And I said to them, you get to buy it from the seller for $500, and you owe me $25,000 because I have the contractual rights in the contract. builders, flippers doing this, right? They're trying to buy up contracts from somebody who has gone out and spent the time to find Mr. and Mrs. Unrepresented Seller who are gonna sell the property for what they consider to be a below market cost. The problem with doing that is, again, you need the seller's consent. So if your buyer is going to do that, we see that reflected in any number of ways, Ryan, Stuart, and or assigns. Well, now do I have the seller's consent? Yes, because they've signed a contract that says it could be to my assigns. Or paragraph 41, other terms. Buyer reserves the right to assign the contract to a third-party buyer. That's what that means, right? I can't balk at it later. And now when you talk about why would the seller get in the way of that if it wasn't, if there's no placeholder in the contract? Well, now as a seller, I find out, so you're gonna sell it to somebody for $525? Who's that person, right? Because I wanna go sell it to them for $520. That way I get $520, you get squat, right? And the buyer gets the same thing they were willing to buy, right? So the purchaser, number one, the contract buyer, that's why they're benefited at the time of ratification for reserving that right to assign.
I just saw a listing today that said no assignability.
Yeah. And some people just don't want that contract being shopped out there. Now, the contract buyer can come in, buy it at $500, and then sell it the next day. But in Virginia, both those transactions have to be funded. Right? You may find a slippery title company out there that's willing to allow you to sell it at $525 before you bought it at $500. It's illegal under Virginia law. So, sadly, neither of your affiliate partners will entertain that. I think I speak for everyone. Okay, we're moving on to sellers now. Tax records, right? They're generally correct, right? I get it that that's our barometer for what we pull in order to be sure we're working with the right seller. But I always recommend just have a conversation with your seller. It's part of your listing appointment. If I was to pull the deed, I assume your name individually would be on it. Is that accurate, right? Whatever the case is, kind of pull the thread there and see how far it goes, right? You're working with John Smith. He says, I've lived in the house for 5 years. You look on the tax record, sure enough, John Smith's there. Lo and behold, we do our title search. John Smith was his dad, and he died 10 years ago. The John you're working with has lived in the property for the last 5 years, but he's one of 3 heirs, right? Each with a third interest in the property, and they don't get along anymore, right? All of a sudden, you have a sales contract where 1/3 of the property has agreed to be conveyed over to the buyer, albeit 2/3 are off the grid and unwilling to sell, right? A non-starter, you're putting money and time into something you're never gonna get paid on and your client's gonna get sued for. So have the conversation, break it down, right? If you hear that a couple has divorced, you're seeing 2 people on the title to the property. And they say, oh, we divorced 5 years ago, by court order the property was awarded to me. The court order doesn't change the title automatically. They still have to have a deed done, deed pursuant to divorce decree or property settlement agreement, where they convey it over to the individual spouse. And if you're still seeing 2 on the tax record, chances are quite good they never did that.
So if you are signing a listing and you decide to actually have something that's convoluted, you just pull a title report with you. How long does that take for you guys to do that?
If you're looking for a full-on title search,
That's my
where we would
question.
recommend that would be perhaps a short sale where your seller is saying, I haven't paid anything, HOA condo, I thought they were suing me and I haven't paid my taxes, all of that. Before you start negotiating with the lender, let's do a full title search. Let's do a full title search and let's figure out what's out there, because it doesn't do us any good to negotiate with a bank when we've got 10 other debtors, like pie holders. If it's a case where they just divorced and the spouse says, well, I feel like we did something a number of years ago, but I signed so many documents, I'm not sure. That doesn't cost anything.
Right.
That, just give me a call, I'll have my abstractor pull a copy of the current deed, I can get it to you almost same day. Like I say, the most recent deed I see just has when they acquired it back in 1995, so you're gonna need something else done, or you're gonna need both spouses on the contract, and I would certainly recommend in that case do the deed first, so you don't have to go to the divorced spouse every time you need a home inspection again yourself.
Okay.
But yeah, title search, couple of days, it's anywhere from $100 to $200, because I have to pay my abstractor.
Right.
Now, the upside of that, though, is if we do the title search and the buyers end up closing with MBH, I can saddle the buyer with that title expense.
Mhm.
If they don't, chances are good the buyer's title company, or even if it's split, they're not going to be able to use our title search because we all have our own approved title abstractors that do our searches for us. But could be a way to put, to direct your contract, to somebody who's already got some background.
Right.
When you say it's generally correct, what percentage of the time would you say it's not?
Well, empirically, I probably only see it when it's not. Somebody's like, look at this.
Right.
So I see it a lot more often. I would probably say if I was guessing, 98, 99% of the time, it is accurate. Like that's what the tax records are there for. The deed gets recorded in the land records, sent to the tax office, and any adjustments are made at that point. So if they're doing their job, it's correct 100% of the time. At the same point, there are bends in the road. Oh, yeah, and just give me a call. I can pull those deeds for you, for sure. I get a lot of questions about a name change. I was single when I acquired it and have now changed my name, or I was married when I acquired it and changed my name accordingly. What do I need to do? When you're having your contract prepared, the contract should be in the individual as their current name, right? I was Ryan Dawes, now I'm Ryan Stewart, right? I'm now Ryan Stewart. That's what the contract is in, even though the tax record is different, right? So make that adjustment. If you are accepting the buyer's offer, you're accepting the absolute mirror image of their offer. You're not making any changes, don't worry about changing it on the contract. We can deal with it after the fact, because there's parallelism in identity. The fact that you're using my maiden name on a contract is of little significance. That doesn't happen very often, of course. Usually we're making some sort of an adjustment that we're sending back over to the buyer. And if you're doing that, change the name to their current name. No new deed needs to be done, nothing new needs to be prepared, and they'll just sign a name affidavit. Deceased spouse, right? This language I put down here really fine print just because I don't want to get caught in the weeds, but it tracks through all these. I'm speaking sort of generally here. If you have a deceased spouse, give me a call and we can talk about the specific scenario, because I want to make sure that I'm not misleading you. But most of the time, spouses are acquiring property with a right of survivorship. Tenants by the entirety. So typically, one spouse passes away, you're still going to see two on the tax record, right? If you're looking at your tax record, you're only talking to one of them, just, hey, I see, John's name on here. John passed away a few years ago. Very sorry. You only need the contract in the name of the surviving spouse, right? So you would be redacting that if you got a contract offer from the buyer with both names on it because they pulled the tax man, right? You want to make that adjustment because we're not agreeing. John, because he's not long gone.
Not available.
No new deed needs to be done. No new deed of confirmation. Not available. Thank you. That is broken for. Contract prepared solely in the name of the surviving spouse, and the only thing that we need in order to underwrite that is a copy of the death certificate. The estate doesn't need to be probated or anything like that. The moment that he died, the property became hers in its entirety. Death certificate affirms that, and we can underwrite it from a title perspective. Estates, right? So here we've got an owner who has passed away without a right of survivorship. So we've got a sole owner that died, or we've got what are called tenants in common. Tenants in common, you each have your own percentage interest. So somebody has died, it is now an estate matter, right? Virginia law kind of takes over here. When you're selling out of an estate, it's either intestate like we talked about before, which means I have no will, and Virginia says who the heirs are. We'll talk about when we've got heirs. Or I have a will, and generally any probate attorney worth their salt is going to empower an executor. An executor is a fiduciary to act on behalf of the estate, and they can sign everything. So if we have that case where an executor is signing, then the contract is prepared in the name of the estate. Estate of Ryan Stewart is the seller. And my executor is just signing that capacity. The executor doesn't have any authority to sell, though, until the estate's been probated. The probate process is actually going to the probate office at the county in which the property is located and recording the will, if it's there, list of heirs, death certificate, and the qualification of the executor. I take an oath as an executor that I will satisfy Virginia law. Until I take that oath, I don't have any legal authority. So that executor signing a listing agreement, unenforceable. You could certainly go after them, but it's not going to do you any good. You can't enforce the listing agreement. And same thing with a sales contract. So you want to be sure that they've gone through that estate process and they've qualified if you've got the executors. If by contrast we have the heirs signing, right? I give the house at 123 Main Street to my 3 sons, equal shares. Now they own it. They're the ones that need to sign. In Virginia, the moment somebody passes away, the property immediately passes to the heirs. Okay? And so those heirs can sign a contract at that point. You don't need to probate the estate in order for them to sign a listing agreement or a contract. What they can't do, however, is to convey marketable title. Because marketable title, we need a title search, and we need to see what happened to the deceased, and that involves the probate process. So while they can sign a listing agreement, they can sign a contract, they may not sign the sales contract. They may not go to closing until the recordation of the probate document.
Are wills attached to your title search, or not? There's somewhere they send separate. If I recorded a will,
Yeah.
and you did title search on my house, that will come up and
Yep.
say, this is all there, okay.
Yep,
All right.
both the land records and the probate records are searched as part of the title search.
Okay.
Yep, but that appointment does need to be made, right? Generally, most of the probate clerks, unless you really know somebody, they're running about 2 to 3 weeks out on those appointments. So if your clients haven't done it, they need to get moving on it. Trust we talked about. The contract is prepared in the name of the trustee, Ryan Stuart, trustee of the Stuart Family Trust. It is not problematic if it just says the Stuart Family Trust. Perfectly fine. But if you want to be technically correct, title is vested in the trustees in their fiduciary capacity on behalf of the trust. That would be how you prepare the contract. Also, we need, just like buyers, we need a copy of the trust agreement. So keep that in mind before it's packed up and it's on a moving van halfway to Florida. Make sure you notify your buyer or your sellers that we're going to need a copy of the trust agreement in order to underwrite the loan. Brokerage discussion. You all, I think I gave everybody a copy of the actual first page of the sales contract. This is that stuff in the boilerplate that we always kind of skip over, right? But if you're preparing it for an unrepresented buyer, the mistake I see quite often is that listing agents will put their own brokerage in both blanks, listing and cooperating, because they think they can't get paid the full commission unless they serve in both capacities. There should never be any knee-jerk reaction to dual agency. Just because there's not another agent on the other side of the transaction does not make you a dual agent. And so in preparing the contract, if you wrote the contract on the buyer's behalf, which you're permitted to do, ministerial acts on behalf of an unrepresented buyer, you're putting your name, Keller Williams, in the listing brokerage and NA or none in the cooperating brokerage. You are still permitted to be paid the full commission in the listing agreement. The listing agreement says I'll pay this to the listing brokerage, and if there's a cooperating brokerage, then the listing brokerage will extend this much money to that cooperating brokerage, right? But if there's none, listing brokerage gets it all, right? So keep that in mind when you're filling it out. Otherwise, you've got that implication of dual agency. So under Virginia law, in order for me to serve as your agent, I need a written brokerage agreement, right? That's only for the benefit of the consumer, right? From the consumer's perspective, I can't come out and say, well, I did all this stuff for you, I was actually your agent. Well, show me the written brokerage agreement. That doesn't exist. Well, tough luck then. There's no commission that's owed because you don't have a written brokerage agreement. The consumer wins. Implied agency is dead for me as a brokerage to assert it against a buyer or seller. But implied agency is very much alive for the consumer to assert it against me. Meaning that if I acted as your agent, I looked like your agent, well, you can say that I owed you all the duties of a full service agent. And the problem when I put in my contract, the listing brokerage is Keller Williams, and the cooperating brokerage is Keller Williams, because I think I need to fill in both blanks, I'm putting out there Exhibit A that says I'm a dual agent. And as a dual agent, what are my responsibilities and obligations? Virginia is very discerning on dual agency, and it says I can't help either one to the detriment of the other. I can't give either party advice on what to offer, what repairs to request. I can't help you with any negotiation vis-a-vis the other party. That's really troubling. And I may have done that simply by putting my name in there. And trickle down of this is, of course, it's not that I start acting that way because, oops, I put my name in there. It's that I keep doing what I think I'm allowed to do, which is representing the seller. And a month later, the buyer takes me before NVAR and says, I had an agent that did nothing for me. Completely predatory to the benefit of the seller. You say, well, I wasn't a dual agent. Well, your contract looks like it was. Right? And now all of a sudden you've breached some sort of agency obligation, all because you thought you had to fill in a blank. Right? Just don't do it. If you're representing the seller, you're the listing brokerage. Only if you're a dual agent do you fill in both. And if you are a dual agent, you've got to play by the rules, which says confidentiality on everything, and I can't give you any advice. Right? I can be your agent and I can do everything for you, or I can be a dual agent and I can do a really crappy job of representing both. Which one sounds better, right? Dual agency is a powder keg of potential liability. The boilerplate, though, says if I am acting as a dual agent, the appropriate disclosure form is attached. The appropriate disclosure form is the disclosure of dual agency or dual representation in a residential transaction. So if you are a dual agent, you got to check the box and you got to attach this form. Virginia legislature is making sure that you get that disclosure signed because they don't want you to do it. So they're trying to create that chilling effect. You've got to get this document signed. The document says you can't do squat. Real property, I promise we're not halfway through just because we've jumped from we are almost done here. That's right. Okay, now we get into the substance. Everybody get comfortable. Now, home stretch here, guys. Identify with specificity, right? And I've given you the language here, right? Fill in as much of this as you can. Now, I don't care if you don't have the deed book in the library and the page in the folio. There may not be a section number or anything like that. But let's try to get that tax map on there. Let's try to get that legal description. Let's try to get the property address. I'm going to talk parking spaces in a minute. With as much specificity as you can, particularly on tax maps, look to see whether there are any outlots. You see this much more down in Fairfax County than you do in Arlington County, so not as big of a threat. But what we've seen before is that I owned this parcel of property, and there was some dead space that perhaps the county owned long ago that they divided up among all the adjacent landowners. And so my property used to look like this, and now it also includes this little piece. And long ago, I probably fenced in all this, but it's actually two lots. This is the buildable one, this is the outlot, and the tax bill on it is $100 every 6 months or something like that. Well, you need both of those lots on your contract. The problem, it's not so much that if you don't, that this is all you get for your $500,000, but rather you've got this major ambiguity. What was the meeting of the minds that we had in terms of what property was going to sell? So long as the buyer wants to buy and the seller wants to sell, you may not necessarily have an issue. But when things break down, and we talked about this in detail on Tuesday, and the attorneys get involved in it, they're looking for ambiguities. If there wasn't an agreement on the underlying real property that was going to sell. I had a closing a couple years ago where a very predatory seller showed up at closing, and he knew that the contract was only in the main lot. And he had this little outlot in the rear, and at closing he sat down and he said, what do you all want to do about the outlot? Well, clearly the buyers had no idea. We didn't have any idea because we just did the title search on the lot that was defined in the body of the contract. Right? Buyers didn't get a survey, so again, it wasn't something that came onto our radar when we reviewed the survey.
Would it?
What's that?
Would it have
Yeah.
shown up on a survey? Because they're going off of a legal description,
Yeah.
right?
The surveyor
And
would,
that be
the
a
surveyor will
survey.
show all permanent improvements that either are part of the real property or appear to be. And so if my surveyor was only searching the main lot, fortunately on this one there was a fence that went like this,
Okay,
and it fenced in the entire outlot.
okay, so.
This was the buyer's only saving grace in this discussion,
Oh, yeah.
because the seller still wanted to sell the main lot. He just wanted to leverage another 15 grand for the outlot out of the buyer. And ultimately, in boiling it all down from a discussion perspective, the understanding from the buyer, the meeting of the minds, for lack of a better term, was that I was buying everything that was fenced in. And if you're only selling me this, well then we've got a major marketability issue because there's an offense encroaching upon a neighboring and unsold parcel. So I'm going to sue you for that marketability if you don't sell me this property for $500,000. And ultimately, the seller just simply relented. We did a quick title search on the outlot. Both properties sold. But this is where this can be problematic. And so
Right.
it's always good when you're on the website, go on that parcel viewer, right? Take a look at exactly what parcel is being conveyed. And if it looks like this, and there's a teeny little triangular wedge behind it, click on it, right?
See who owns it.
See who owns it.
Yeah.
And if the current owner owns it, perhaps there may be a discussion that should be made. Even if you're not figuring this out till home inspection, well, you've still got that right to void and say, hey, I noticed this, I think it's a glaring discrepancy in our contract, we need to rectify it. No, we're not gonna sell you that triangle. Well, it's fine, then we'll just cut our losses now because we don't want this problem. Or we're gonna hire an attorney because that's not what was presented to us. But look at the listing, if you can find an old survey, communicate with listing agents. These are rare, but this illustrates the point very well of detailing with specificity.
And like, is there anywhere that I can pull legal descriptions, like a county clerk website or somewhere where I can go on and put in the county, the seller's name, and pull an actual, like a warranty deed and a legal description attached to that deed?
Yeah, I mean, all the counties have subscription style services,
But you
which of course as a
subscribe to.
title company we have
Yeah.
access to, so if you need something,
Yeah,
give me a call and I can have it pulled on your behalf.
yeah.
The best that you can do from the public records perspective is the short legal that exists
Yeah.
in the tax record.
I
You know,
just- yeah.
LT 5, SEC 4, that kind of thing.
My first broker just like scared me the bejesus out of me down in Georgia about a legal description, and we have to attach the legal description to all our contracts. And so like, I'm a member of the Georgia Superior County Clerk Office, and I have to pay $15 a month, and I could go on and pull any legal,
Yeah.
any deed for any property, and it saves me a lot of time.
Yeah.
And so I
Same
just
thing
have
with CPAN on Fairfax
always
County,
wondered
Arlington
if
County has
they
a
had
subscription
something
service.
like that here.
They cost
but-
money and it would be cost prohibitive.
Yeah, it doesn't sound like that's just like a normal thing.
And incidentally, I believe that is the first thing on Kelly's job description is to scare the crap out of them.
Yeah.
It's,
So when you're filling in the, blanks up there, I noticed under legal description it says lot with an S, so you can have more than one listed,
More
would
than
it
one.
have a different tax ID too?
yes.
Okay, so you just put them both, you don't need a separate.
Now, quite oftentimes, like particularly in Arlington, you've got these little lots that are 2,000 square feet. So it could be lots 38 through 42,
Okay,
but it's one tax map,
okay.
right?
All right, so,
Just the
but
same,
everything can be included
you may
on
have
one
an
as long as
outlot
you
that is
list
a
them
separate
all.
tax
Okay.
map, right? So don't just assume that there's always parallelism, one lot, one tax map, it doesn't always work. And then our final topic is parking spaces. Obviously, you all practice all over the place, but certainly I would anticipate practice in Arlington. Arlington has a lot of condos. A lot of condos have a lot of parking spaces. So this is something that you need to understand, and you need to understand the mechanics of it. Again, hearkening back to our last point, as much specificity as possible on this. If you know only that there's 2 spaces that are pertinent to the unit, you put a 2 in the blank. Right? If you're looking on the tax record, it says A1 and A2, put A1 and A2 in the blank. As much specificity as you can put in here to avoid any potential ambiguity going forward.
Excuse me, does anyone drive a white GMC?
Yeah, I do.
Oh, you are a troublemaker. Thank you very much.
I am sorry.
I could have warned you. She's the one you have to look out for sure. All right. Very good. The tricky part about parking spaces is they are appurtenances. They are limited common element. An appurtenance means something legally attached to the unit. The example I give is the mailbox. It's a big bank of mailboxes down in the lobby, but you have your own. That's an appurtenance. Perhaps the storage unit. Everybody gets one storage unit. That's an appurtenance. And pursuant to the sales contract, see up here, the buyer will buy and the seller will sell entire interest with all improvements, rights, and appurtenances. So I'm telling you in the boilerplate, I'm giving you all appurtenances. Right? Described as follows. And then the issue we sometimes have is this is left blank. Even though there's a parking space that is appurtenant to the unit that gets to be used by the seller and is going to pass over to the buyer. So I'm telling you I'm giving you all appurtenances. I'm saying it includes, and then I've got a blank. So now I've got an ambiguity. And again, ambiguity is the enemy of any contract because it can be used to invalidate the contract when the whole house of cards falls down. The great majority of the time, of course, that's not a problem. But all the more reason we want to define with as much specificity as possible what parking space conveys. they're appurtenant, and pursuant to the association bylaws and Virginia law, they convey automatically when the property is sold. So if I have a sales contract that says I'll give you unit 101, and I'm silent on the issue of parking spaces, nothing is ever mentioned. Regardless of whether those parking spaces are in the body of the contract or not, now the good title attorney will see that and call, be sure, hey, I want to make sure we've all got the same expectations here. But regardless of whether it's in the contract or not, when that unit gets sold, all the appurtenances go with it, including the parking spaces that are attached to it. So if your seller is executing a sales contract that has a blank there and thinks that means they're not conveying the parking spaces, they are incorrect, because those spaces are assigned to the unit. Where the unit goes, the spaces go. Yes?
So in some condo buildings, or some of the ones I've been helping a buyer look at, she's always asking, is there a parking space, and usually it's listed. But then we were looking at one where they were selling the parking space separately. So does it, sometimes some buildings have a parking space and others you own the parking space separately?
Yeah.
Okay.
And so what I've said here is people get funny, they get sideways, they try to be tricky with their parking spaces. And so you may have a seller that sits down and says, well, I own multiple units in the building. This one has a parking space attached to it, because that's what the associations do. They assign, the space isn't owned by the unit. The space isn't owned by the seller, by the unit owner, but rather the space is tethered to the unit, and the owner owns the unit, if that makes sense, right? But the example there is, I can't just go sell the parking space to some guy on the street, right? It has to be a unit owner, and not because they want it with unit owners, but rather because it's tied to a unit, right?
Can it be tied to a different unit then if you sell it?
Well, and
Does
so
somebody
you have this
in
sort
the
of
building?
legal fiction that you're selling a parking space. When in reality, what you are doing is you are transferring the right to use the parking space from the owner of one unit to the owner of another unit.
Okay. Then does it become attached to the one?
And then it becomes attached to another. But when we're talking about selling it, it's not a deed,
So there's
right?
not a deed
It's
for
not a
parking
handshake,
spots.
right?
Okay.
It's not just money transferred, but it's rather a reassignment of limited common element. And anytime you're reassigning the limited common element, the association has to consent to that. You're technically changing their covenants, right?
This could apply to a parking spot or a storage unit.
Parking spot or a storage unit, yeah. And so you'll get your seller that says, I own 5 units, right? The one I'm selling has the best parking space, right next to the elevator, you know, it's 12 feet wide, I love this space. So I'm actually, but I've got one down on the, the bottom floor that's, underneath the HVAC and, stuff drips on it all the time. So what I wanna do is I wanna sell unit 101 with parking space B, right? Right? The problem is parking space B isn't attached to unit 101. And so simply by putting in the contract, I'm selling you unit 101 with parking space B, it's an impossibility at the time the contract is signed. And of course, at the time the contract's signed, you're conveying equitable title, right? It's not an appurtenance to this unit. And so if your client wants to do that, number one, you need to be specific in the contract about what's going to happen between ratification and settlement. And number two, all of that needs to take place prior to the transfer of the deed. Right? You go to the association, the owner of unit 101 conveys parking space B to the owner of unit 102. The owner of unit 102 conveys parking space A to the owner of unit 101. And I, as the owner of both those, can sign all that, but then we give it to the association. The association signs that reassignment, and then that gets recorded in the land records. And that has to happen before the unit is sold.
Okay, so they have to do their internal stuff behind the scenes as such before then it can go into the contract.
Because if it happens after the unit is sold, guess who now owns the parking space? The buyer.
Absolutely.
They need the buyer's consent to do it. And we see parking spaces, I get this call from clients all the time. I did this closing a couple years ago, and I meant to withhold this parking space, and now I'm finding out that it went with another unit. And I have to explain this whole process to them. So I'm consistently having this conversation when getting a sales contract, getting my title work to show that there are parking spaces appurtenant, to try to figure out what did the parties intend, and better yet, because the contract has no similarity to what the title says, trying to figure out how we reconcile this before we get to sell. Because it always requires that reassignment through the association. And most of the time, people don't understand. They just think, well, I'll only convey unit 101 in the deed, and I'll convey parking space A later. I'll hold on to it, because it's not in the legal description that it somehow doesn't pass. Every single condominium description says unit 101 and the limited common elements are pertinent there too. Even though it's not specific on the parking space, it conveys. Okay? So when you get parking spaces, be as specific as possible on the selling side, on the listing side. Talk to your seller, just be sure. Hey, you've got these 2 spaces, we're conveying those 2 spaces, correct? And if anything's sideways, give me a call and we can help you with it. All right. I would say slightly lengthier discussion than I anticipated, but I tend to be long-winded, and I wanted to be detailed as well, because that's kind of what we're here for. Those are all of the talking points. If you need me, give me a call. Let us know if we can help you with any kind of transactions. My office is right there, so if you have questions on this or anything else, don't be a stranger. Stop in, say hi, and that's what they keep us around for. All right?
Thank you.
Very good. More to come. Next month we will dive into the dense and chewy world of price and financing. So. Very well, guys. Thank you so much for the great
Ryan.
questions, attentiveness. Shut this thing down.